Far and wide, people are celebrating Afroman's win in the lawsuit brought against him by members of the local police department. Personally, one of my favorite parts about this whole thing is that this case has even reached the notice of political commentators on both sides of the political aisle, and everyone seems to agree. This case is both hilarious and ridiculous, and it's a very good thing that Afroman won. This year is America's 250th birthday, and I personally did not foresee that our great unifier would be Afroman of all people. 2026 is turning out to be a pretty wild year already, and we're only around the end of Q1. But unfortunately, that joy has been dampened for many people by the realization that when entering judgment in the case, the court recently split the court costs between the parties. That is, instead of telling Afroman that the plaintiffs have to pay all of the court costs because they lost everything. Instead, the court said, split these evenly between the two of you. And after reviewing some Ohio law on this topic, I do find it not just crappy, but also a little bit perplexing. In this video, I'll talk about why that is. And we'll talk about why this case really shouldn't have cost Afroman literally anything at all in the first place. No costs, no attorney's fees, and why, with just one tiny twist, his fate actually could have been different, and this case could have been dismissed years ago at a very early pleading stage. Let's get into it. Okay, so for those of you who need a quick recap on this case, here it is in a nutshell. Back in August 2022, the Adams County Sheriff's Department raided Afroman's home on a warrant for drug trafficking and kidnapping. They found nothing, and he was never charged with a single crime. So he did what probably any artist would do in the circumstance where his home is raided and he's got all this damage to pay for himself. He turned the experience into music videos using his own home security footage, criticizing the police department and mocking them for the whole experience.
Will you help me repair my gate and door?
Those videos went absolutely viral. But then 7 deputies turned around and sued him for defamation and invasion of privacy. The case eventually went to a 3-day jury trial in March 2026. And after about 6.5 hours of deliberation, here's what the jury decided.
In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdicts.
Total victory for the defense on all claims. Now, if you want a more fulsome breakdown of this case from start to finish, definitely go check out our first video on this topic. It's linked right in the description below. Otherwise, let's focus in on what happened after the verdict. Because on March 20th, 2026, Judge Jonathan P. Hine entered the official judgment entry in the case. And as expected, the court entered judgment on behalf of the defendant. But right at the very end of that judgment entry, the judge includes this one line. It says that costs are divided 1/2 to the plaintiffs and 1/2 to defendant Foreman. Now, people who took notice of this were quick to note their shock and even anger over this. I mean, this man just won every single count, and the court is making him pay half the costs. And what reasoning does the court give for this? It says it's based on the quote-unquote relative merits of the case and the justiciability of the claims. That's it. That's the whole explanation. There's no further reasoning, no analysis, nothing. At least not in this written entry of judgment. And honestly, when I read that, I was like, this is kind of weird. And I'll tell you why in just a moment. But first, I do have to thank this video sponsor for making videos like this possible. This video is sponsored by Honeylove. Honeylove is an independent, female-founded brand with products designed by women who actually wear them. They make bras and shapewear, but they also have a full line of tanks, bodysuits, and underwear as well. And they make these items with supported structure, smoothing fabrics, and premium finishes. Recently, Honeylove launched their new crossover contour bra, which features their best-selling wireless crossover bra design, plus built-in molded light foam pads for extra support and a beautifully contoured shape. So recently, Honeylove sent me the crossover bra and the Superpower Brief. Given that I am around 6 months pregnant, I couldn't actually test out the Superpower Brief, but I will say the quality of the item in my hands feels very high. And I really can't wait to try it out postpartum. But the crossover bra I have been able to test out, and I will say it is the most comfortable bra that I've worn in a long time. I just mentioned pregnancy. If you've been through it, you know that there are all kinds of changes that happen to your body over those 9 to 10 months. And that means that a lot of your items in your wardrobe start fitting you differently or just become downright uncomfortable. With that in mind, I have to say, the moment that I put on the crossover bra, I could feel an instant difference from all of my older ones. It's supportive, but doesn't feel overly restrictive. And it doesn't cut into you in weird ways because it smooths everything out. So long story short, I am actually looking into buying more of these myself. And if you're looking for some good bras and shapewear that you can comfortably wear and which actually look good when you're wearing them, check out the link in the description below so you can get 20% off your order. And thanks again to Honeylove for sponsoring this video. Okay, so let's get back into the video and talk about why this is also weird. So to do that, we first should talk about what Ohio law actually says about court costs. Under Ohio's Rules of Civil Procedure, Rule 54D, costs are supposed to be awarded to the prevailing party, in other words, the party that wins, unless the court decides to do otherwise. So the rule is pretty straightforward. If you win your case, you get your costs covered. That is, unless the court has a good reason to do something different. Now, what this really means, though, is that the court can change this using its own discretion. And because of that, the Ohio Supreme Court has said that to overturn the trial court's decision on this, they have to find that the trial court abused its discretion. What that means is if Afroman wanted to appeal this cost-splitting decision, he'd have to show that the court made a clear, obvious error. I will say that is generally a pretty high bar. Anytime the court has discretionary ability to make a decision, it's pretty hard to overturn that because usually appellate courts are going to find a lot of reasons why that discretion may be merited. But here's where I start scratching my head. You see, usually when you see a court split costs at the end of a trial, it's because of a situation like where both sides scored some kind of victories. Maybe the plaintiff wins on liability but loses on damages. Or maybe the jury sides with one side on one claim and the other side on another. But that is not what happened here. Afroman got a clean sweep.
In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdicts.
This wasn't a mixed verdict. The jury rejected every single claim. There was no scenario where the plaintiffs won on one issue and Afroman won on another. And the court gave virtually no reasoning for why it decided to split costs anyway. Now, it's entirely possible that there was some kind of oral argument at the very end of trial on this issue, and that maybe this happened after the camera stopped rolling. So maybe there is some context that does exist, but just isn't apparent from the written order. But without that context, a lot of people are thinking that this is because the judge is simply biased against Afroman. And look, I get why people feel that way, but I don't know that I fully agree with that take. Because if you look at the court's other rulings earlier in this case, some of them are actually pretty favorable to Afroman. For example, back in October 2023, the court ruled on the defendant's motion to dismiss. And the court actually dismissed some of the plaintiff's claims because he said the officers couldn't show that their names or likenesses had any commercial value. And what's more, the court specifically noted that as public servants, these officers should expect commentary and criticism about their duties. In other words, nut up, Buttercup. The court also rightly classified these officers as public officials under Ohio's libel law, which is a classification that makes it harder for them to win their defamation claims against Afroman. So was this a court that was out to get Afroman? Personally, I don't think so. But I will say this, the cost-splitting decision without any real explanation is perplexing to say the least. And it sucks that a man who just won on everything and has already had to pay for so much that he really wasn't responsible for now has this happening. And what's honestly most frustrating about this whole situation is that the way I see it, but for a stretch of simple bad luck, Afroman wouldn't actually be paying for literally anything here. No costs, no attorney's fees, and the whole case would have been dismissed ages ago. And it's all because of Ohio's anti-SLAPP law. So let's talk about that. Now, we've talked about anti-SLAPP many times on this channel, but if you haven't heard of anti-SLAPP or SLAPP before, SLAPP stands for Strategic Litigation Against Public Participation. It's essentially when someone files a lawsuit pretty much entirely just to prevent a person from exercising their First Amendment rights. In other words, it's typically where someone sues you not because they have a strong legal claim, but because they want to silence you. They don't like whatever it is that you're saying, their fifis are getting hurt, and they want to punish you for speaking out about something. And that's exactly what Afroman has been saying was the actual purpose of this lawsuit filed against him.
I figured, like every American, that I have freedom of speech. So with that freedom of speech, I wrote songs about my experience, hoping to raise money to pay for the damages they done to my property.
And so an anti-SLAPP law is designed to protect people from exactly this kind of lawsuit. Now, one thing to note about anti-SLAPP laws is that they are state-specific, and each state's anti-SLAPP laws come from a statute passed by their state legislature. Some states have very strong anti-SLAPP laws, and some have very weak ones. Some have none at all. California, for example, is known as having one of the strongest anti-SLAPP laws in the country. So in April 2025, Ohio enacted its very own anti-SLAPP statute. And based on my reading of this statute, it looks like it actually is a very strong one, right up there with California's, meaning that it makes it easier to dismiss it under the anti-SLAPP law. In other words, better for the defendant. This one is called the Uniform Public Expression Protection Act. And here's how it works. So this law applies when someone files a lawsuit against you over your exercise of free speech on a matter of public concern. Now, does criticizing a police raid on your own home count as free speech on a matter of public concern? Yeah, that's basically the definition of a matter of public concern. So yes, this case 100% fits into Ohio's anti-SLAPP law. And the thing is, when the case fits like that, the defense can file an anti-SLAPP motion to dismiss the case within 60 days of being served the complaint. So right off the bat, before this case has a chance to get going and run up a bunch of attorney's fees with things like discovery, the defense can file an anti-SLAPP motion right away. And here's the beautiful thing. Once that motion is filed, the entire case gets stayed. Essentially, it's frozen in place. There's no discovery, there are no depositions, everything just stops while the court decides the motion. And now here's the best part. If the court grants the anti-SLAPP motion, meaning that the defense wins on the motion, the law says that the court shall award reasonable attorney's fees, court costs, and other litigation expenses. This means that if the defense wins the anti-SLAPP motion, it is mandatory for the plaintiff to pay for all court costs, attorney's fees, and other reasonable expenses. There's no decision by any judge. This is required under the statute. And the thing is, I really do think that Afroman would have won on an anti-SLAPP motion had he filed one. That's because the law says the court has to dismiss if three things happen. First, the defendant has to show that this whole lawsuit is based on something he said or did that basically was constituting him exercising his First Amendment rights, talking about a matter of public concern. Second, the plaintiff has to fail to show that this falls under one of a handful of exceptions, like where the lawsuit is filed against the government. I haven't gone into any detail about these exceptions, but suffice it to say, none of those fit in this situation. And third, and I am simplifying this one a bit, but basically either the plaintiff fails to essentially prove each essential element of the claim, or the defendant shows by proving that it's impossible for the plaintiff to prove their case. Now, that last one might sound like we're splitting hairs a little bit, but basically the distinction between those two is each side successfully meeting a burden of proving or disproving whether the plaintiff has a case. And in this case, I think Afroman likely would have been able to successfully hit all of these requirements to win an anti-SLAPP motion against the plaintiffs. And that would mean getting this whole case dismissed right at the beginning of the lawsuit. And even before that point, the whole lawsuit would have been stayed immediately. No 3-year legal battle, no depositions, and ultimately no trial. And then after winning the motion, Afroman would have had all of his attorney's fees and court costs paid for, courtesy of these plaintiffs. Instead of arguing over a cost split after a 3-day trial, Afroman could have walked away without having to pay a single dime. So then there's this question, why didn't Afroman file an anti-SLAPP motion? Well, the answer is, unfortunately, frustratingly, that he couldn't. You see, Ohio's anti-SLAPP law didn't go into effect until April 9th, 2025. And meanwhile, the deputies filed their complaint on March 13th, 2023. That's over 2 full years before the anti-SLAPP law even existed. And even though the lawsuit was still ongoing at the time that this was enacted, and obviously the trial happened much after this law was enacted, under Ohio law, if there's nothing in a new law that expressly says otherwise, a statute that is enacted is presumed to be only prospective in its operation. That basically means that when a statute is enacted, it's only forward-looking. If there's a lawsuit that's already in play at the time that it's enacted, you simply can't use it. And in this case, it looks like the Ohio legislature did not include any of that kind of language in the anti-SLAPP statute that would expressly allow this law to work backwards for a case like Afroman's. So because this lawsuit was filed before the anti-SLAPP law went into effect, Afroman simply couldn't use it. And that is just sheer bad luck. Now, as entertaining as this trial was, and as grateful as we all are that cameras were allowed in the courtroom, I think most people would probably agree that it would have been much better for Afroman to save at least tens of thousands of dollars on attorney's fees and just win on the same First Amendment arguments he made at trial. But instead, threw an anti-SLAPP motion at the very beginning. At least, I don't know, that's how I feel anyway. But those are my thoughts. What do you think? Do you think maybe that the court was justified in splitting the costs between the parties, even though Afroman had a clean sweep victory? Or do you think that's just plain unfair in a long saga of events that have been completely unfair to Afroman before now? And do you think that Afroman should try to get that cost decision overturned on an appeal? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you need help for a real legal issue in your life, contact us at the Bytes Law Group at our website, linked in the description below. Now, something that can make a big difference in these cases is whether or not your case is in the hands of a good lawyer. And so many people are out there fighting these battles without the best person on their team. I started Legalbytes because I saw this massive gap between how the legal system actually works and what most people understand about it. When you don't know your rights and you can't understand legal jargon that's used, when you're intimidated by the whole process, that's when you're most vulnerable. Making these videos, breaking down trials, explaining the law in ways that actually make sense to most people, that has been incredible. But after years of doing this, I wanted to do more. Because the thing is, when you're facing a real legal problem, you need someone in your corner who gets it. And that's why I created the Bytes Law Group. It's the same mission as this channel. Make the law work for you, not against you. Whether you're dealing with a consumer issue, you've been wronged by a company, or you just need someone to fight for your rights, we are here to help. I built this firm on the same principle as I built this channel. You deserve to understand what's happening in your case. You deserve straight answers, and you deserve a lawyer who treats you like a person, not a case number. We are taking the same approach that I take in every single video, breaking things down, empowering you with knowledge, and actually giving a damn about the outcome. So if you need legal help, check out Bytes Law Group at bytes.law, also linked in the description below. And if you don't need us right now, that's great too. I hope you keep watching, keep learning, and keep growing your understanding of your rights. That's how we make the world a better place.